Good afternoon, everyone.
Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon. I was just wondering if you all were asleep.
Mm-mm.
No?
No.
Wide awake. Wide awake.
Oh, that is wonderful. Did you have an opportunity to read the 3 cases I sent?
No,
No?
I just got this is my first class. I just got my stuff today. I didn't get a chance to look at it. Sorry.
Okay. Anybody else?
Good afternoon. Same here, first class today. Was unable to get anything. Just started this morning.
First class too.
Uh, oh. So, okay, there's 3 cases to discuss. So I don't know if you want to take a couple minutes.
Are the cases on the handlet and on the handout?
No, I would have sent an email.
No, I didn't get that.
Okay, hold on. Hold on, wait a minute. And then let me send it. Give me 1 second. Look on the register. That would be who just joined? That's Laurie.
Laurie.
And who?
Yes, good evening, Ms. Archer. Yeah, we have, I think, 3 or 4 new persons joining us tonight.
Okay. So
I
first,
think I probably have sent you, I had to send you a revised,
saw that.
schedule.
yeah, I saw
Yeah,
that.
so we might have to, either me or you will have to resend an email link to them.
Miguel, you dropped. Okay, can you forward to them the email with the link to the cases, the 3 cases?
Yeah, I'll do that right now. I'll do
Do
that
that
right now.
Okay, so they could have a read of it.
Okay.
Okay. All right, so the new persons are just getting their reading material.
I mean, I have the booklet.
Okay,
Copy of
okay.
that we sent.
Okay. All right, so he's gonna send you the email right now so you can pull down the 3 cases.
Okay.
I'll give you a couple minutes to get that. You can let me know once you receive it. Then you could download it and we could start. Because the others in the class would have already had an opportunity to read it, so then you could just join in.
Okay.
Okay, I see he's sending it now. Okay, so can we begin? Sound so.
Yes, ma'am.
I'm still waiting on him to send it, but
Yes, I saw it flash on my screen.
Miguel probably got something against me, but you know, I haven't received it as yet. So
Okay, hold on then. Let me look at what he sent. He have something against you? That's not true. Let's see. What's your email?
kk31@hotmail.com.
Yeah, he sent it.
No. I do have some against Kwame Ryan. Sorry, I do.
He's on here on the list. You still don't see it?
If he sent it, I still haven't received it. I'm checking both my junk mail because that's where most of his stuff go anyway. And the
It
and my-
says kk31@hotmail.com.
yes,
I
ma'am.
haven't received mine either. This Rosalie Monroe.
Rosalie, let me see. Rosalie. Miguel, I don't see Rosalie on this list. Rosalie.
Okay, let me see. I checking my email now. I don't see, hold on.
Rosalie Rosalie isn't on it.
Um,
Miguel, send it to Rosalie. I don't see why Thingham isn't on it. Kwame, he should have been there.
Like-
Okay. Kwame, you still didn't receive it?
No, ma'am. Still didn't receive it. So
Okay, you on the internet, right?
yes, ma'am. Yes, ma'am.
Okay. Put key in key in Montague Investments Limited, MONTAGUE Investments Limited, plus a plus sign, Supreme Court. A case should come up. Montague Investments Limited and Westminster College and Mission Baptist Church.
So we're not, are we looking at the
Sorry, you
petition
can
of
send that to
Sa-
me again?
It should say Montague Investments Limited plus Supreme Court of the Bahamas, and then you click the actual case from the Supreme Court site.
That's the petition of Simon F.B. Rodden?
That's a different one.
Okay, so that's not the one you're looking for.
No, you need that one too.
Okay, let me look for the next one then.
Okay, we're doing 3.
Okay.
We're doing Simon F.B. Rodin. We're doing Montague Investments Limited, and we're doing Milton and Daniel Strawn.
Okay, this one is Milton and Daniel Strawn. I got that.
Okay, Court of Appeal.
Yeah.
Ms.
Okay.
Bethel,
Yes,
you received that email that they, with the cases?
I just got it. I got it just now.
You could forward it to my BLECCU email.
No problem.
Thank you.
Ms. Archer, could you give me that address again? Because I'm seeing a bunch of Montague Investment Limited.
Come up.
Yes, ma'am, I'm noticing a
Okay.
bunch come up.
Yeah, but you want the one that says the link that directs you to the Supreme Court. Supreme Court of the Bahamas.
Rosalie, I sent it.
Okay, I looking to see if it comes through right now.
And you said Westminster College Limited? You said Westminster Court College Limited? Ms. Archer, you also saying Westminster College Limited?
Yeah, and Mission Baptist Church.
Okay, I have the one from Mission Baptist Church.
Ms. Bethel, I don't see that.
Okay, I'm here. It dropped. You found it, Kwame?
Yes, ma'am. I
So the next one will be Simon F.B. Rodin in the Supreme Court. And then the last one would be Milton and Daniel Strawn in the Court of Appeal. So let's start the chapter. and then we'll look at the cases. So chapter 2 is talking about understanding the conveyancing process. So we know the first thing you have to do before you obtain a mortgage is you have to purchase an interest in land. And everybody knows that purchasing an interest in land is a major investment and it is a commitment. And you know, during the recession, and you'd have seen this in the last, what, 6-7 years, a lot of people have lost their homes because they were unable to keep up with the commitments. So when it comes to purchasing an interest in land and obtaining a mortgage, it falls under the Conveyancing and Law of Property Act. And in addition to that, when it comes to litigation, dealing with property or land law, of course, we follow the Bahamian legislation, but there's also case law. And that's Bahamian cases and also English cases. So the first thing when you're purchasing an interest in land is you have to enter into a contract. And to enter in the contract, the first thing is there has to be an agreement between the vendor and the purchaser. That means that one person has offered to sell and the other person has said that they agree to purchase the property for a certain sum. Now, normally this is done with the assistance of a real estate agent, and sometimes it's just done between the vendor and the purchaser. So in the agreement for sale, it normally outlines the terms and the conditions of the sale of the property. So we'll have the purchase price, the deposit, the completion date, which is normally about 3 months. You'll have the obligations of the vendor, which is always to give good and marketable title, and the undertaking by the attorney for the vendor and the purchaser. And of course, the consequences if the vendor fails to prove good title, or if the purchaser fails to obtain financing, if he's going to the bank for a loan, or if the purchaser is unable to complete the transaction within the time period. So all of that is in the agreement for sale. So once the agreement for sale is agreed, a deposit is paid, usually 10% of the total purchase price. It is paid to the attorney at the date of the execution of the agreement for sale and is held in escrow pending the completion of the transaction. Now we get to the part of where the vendor now has to provide the original receipt and copies of his title documents. And this abstract of title covers a period of time fixed by the contract. And in time, the vendor will be asked to verify the contents of his abstract. So the vendor has to deduce his title before the exchange of the contract. That's normally how it's done. And this permits the purchaser to, I guess, get some kind of comfort that he is satisfied with this arrangement and he wants to be contractually bound to buy this property, an interest in this property. So the next step after he feels comfortable, he's signed the contract, he's giving his 10%. Now he wants to have this title investigated. So the purchaser attorney does the investigation. And he does that by conducting what we call a title search. Title search begins with making sure that there is no causes in the Supreme Court registry. That means there's no judgment against that property. Or if there's any matter in the courts from previous owners regarding that property. They'll also look to see if there's any charges in the registry against the vendor himself. So the purchaser's attorney confirms whether the property has a proper chain of title. And the proper chain of title means that he has to go back, he should be able to go back at least 30 years or go back to a point where the land was granted or leased by the crown, or he goes back to where there was a certificate of title in accordance with the provisions of the Quieting Titles Act. Whichever one of those three is shorter, then the attorney for the purchaser will come to the conclusion that yes, he is able to confirm that there's a proper chain of title. Now, the attorney will also investigate whether there are any outstanding real property taxes on the property, whether there's any association maintenance fees, any unpaid utility fees, and if, depends on whomever the purchaser is, if approval is required from the investment board, those applications also have to be made. And that's normally done by a non-Bahamian or foreigner. Now, the purchaser's attorney can raise requisitions, which means that when he looks at the title and he looks at the sale and purchases up to one of those 3 periods, he can ask questions or he can make inquiries. And he can do that on the title and any other matters that relates to with the vendor. After investigating the title, then any requisitions on possible defects in title, he can approach the vendor's attorney. The purchaser's attorney will also reserve the right to raise further questions or inquiry on the title. And that depends upon the responses that he will receive from the vendor's attorney and any other investigations of title. Now, knowing that the agreement for sale provides for a specified period, and normally 14 days from receipt of the title documents for requisitions to be made by the purchaser's attorney. So after investigating the title, the purchaser's attorney may raise questions on the requisite government and subdivision approvals, any outstanding real property tax assessments and utilities, the survey of the property, and any pertinent easements or right-of-way and or restrictive covenants. So remember from last class when we would have gone through easements and rights-of-way and restrictive covenants, as a part of making sure that you have a clear and clean title to property, the attorney must also make sure when he's doing his title search, whether or not there are any of those easements or rights of way and restrictive covenants that run with the land. Once he is satisfactorily answered all of the questions and inquiry, then the purchaser's attorney will require a report on title. He prepare one, and that report on title and or the relevant lending institution receives a copy of that report on title. The draft conveyance is then prepared by the vendor's attorney and is reviewed and requisitions the title and the causeless searches by the purchase attorney or subsequent to such requisitions. The conveyance will include the name and addresses of the parties, any reference to earlier title documents, a detailed completion or detailed description of the property, any restrictive covenants, any easements, any rights of way, a plan of the property, the appropriate affidavits of citizenship and witnesses, and any other information that is relevant to the conveyance. So once completed and is appropriately amended and approved, the conveyance is finalized by the vendor's attorney and is executed by the vendor and the purchaser. Then their signatures are witnessed. Because remember now, Whenever there's a transaction related to land, it must be by deed and it must be in writing, and the signatures have to be witnessed. A completion statement is prepared by the vendor's attorney, and the balance of the purchase price is paid by the purchaser's attorney or by the purchaser, him or herself. And that'll be less the vendor's portion for any stamp duty and apportionment for real property tax or any rates, any assessments, any utilities. Because remember, at the very beginning, when they are contracting and they are coming to an agreement, the vendor and the purchaser can agree as how certain expenses are to be proportioned. The legal fees may range from 1.5% to 2.5%, and they are paid on or before the completion by the vendor and the purchaser to their individual attorneys. Commissions to real estate agents are also paid at this time. Requests are made to utility companies to return deposits to the vendor, and all utilities and real property tax assessments are placed in the purchaser's name. So once the balance of the purchase price is paid to the vendor's attorney, subject of course to the completion statement, and the vendor or his attorney acknowledges receipt of payment, then the property transaction is complete. The conveyance is sent for stamping at the public treasury, and the stamp duty is paid on a conveyance, which is normally split between the vendor and the purchaser, and is based upon the total consideration or the purchase price of the property. Now, if you are a non-Bahamian, you can purchase property in the Bahamas, and most of them actually, when they're purchasing property in the Bahamas, they do it via an IBC, an international business company. And they'll use that to act as a property holding company. And this property investment vehicle allows that non-Bahamian, as an investor, he enjoys confidentiality, anonymity, limited liability in owning his property. And that is how he will structure and manage his wealth, through companies. So non-Bahamians are required under the International Persons Landholding Act to register their purchase with the Bahamas Investment Authority, and by obtaining a certificate of registration. Otherwise, they require a permit from the investment board prior to their purchase. A certificate of registration is not only required for vacant and non-vacant land, but also condominiums or property under 2 acres that will be used as owner-occupied property. A permit is required by non-Bahamian property owners for the purchase of property that is 2 or more contiguous acres, to rent out all or a portion, or where the property will be used for commercial purposes. Non-Bahamians must also obtain a permit for any subsequent purchase of property. A permanent resident are required to register their purchase of real property, whether vacant or non-vacant, but they are not required to obtain a permit. A non-Bahamian lender that acquires security on properties in the Bahamas, they actually have to obtain exchange control approval from the Exchange Control Department and a permit from the Bahamas Investment Board. Any questions so far?
I have a question. Is the permit renewed every year, or is just given one time and that's it?
I think it's
To the
given one
non-Bahamian?
time. I don't recall it being renewable.
Okay.
Because you know, when a non-Bahamian purchases property, he may purchase the property in order to build a second or third home. Or he may purchase the property to build a dwelling in order to rent. Or they purchase a property and they hold it for a certain length of time, and then they sell it over at a higher price. So they keep it as an investment. And they wait for the price of land to rise and then they sell it off. So let's look at our first case. Let's do Milton and Daniel Strawn and Harcourt Strawn. This is a quieting title matter. And remember, I said there are three ways in
Hi.
which you go back.
Sorry to interrupt.
Go ahead.
I just wanted to say the permit is a one-time flat fee of 500 and they don't have to renew it.
Yeah, just flat. That's what I'm telling her. I've never seen it being renewed.
Yeah.
Yeah. Who want to start with Milton, Daniel, and Harcourt Strawn? No eager beavers?
What page are we on, ma'am? Good evening.
Good evening. We're going to discuss the case of Milton Strawn and Daniel Strawn.
Where can I find that?
We would have sent the link.
No,
Again,
my stuff just got sorted out today, so I wouldn't have gotten the link. Oh,
he just
okay.
resent it. He just resent it.
Okay, thank you.
Look in your mail. Do you see it?
No, ma'am.
Also, the link is in the chat now.
Thank you.
Okay.
Sorry,
right,
what
go
chat
on.
are we referring to? Could I ask which chat are we referring?
The
Hello?
chat, the chat for the Zoom meeting. Ms.
Oh.
Raming put it in here already for us.
Okay.
Okay, let's give them a couple minutes. Who wants to start? Okay, Lisa, you want to start?
Where am I starting from?
This is the Milton Strawn
civil.
matter.
Civil appeal?
Yes.
Okay.
So you would start from paragraph. And you don't read all of this. This is a lot.
It is.
So this is a matter where they want to set aside a certificate of title that was previously granted under the Quieting of Titles Act. And they're saying that they're doing so on the grounds of deceit and fraudulent concealment. So Milton and Daniel Strawn are appealing a decision that was made in the favor of Harcourt Strawn. So in order to get the gist of exactly what is happening in the case, you have to start by reading. Did anyone read it at all?
But I just got it today, so I
No,
I
not,
didn't-
okay, no, won't be you, be someone from the last class.
So you just want us to read it right now? That when you say start, you just want us to read it?
You can't read all of it. There's certain sections in it that you should read, not all of it. It'll take too long.
Okay, so when you say
That's-
start, you just wanted the discussion about what we would have
Yes.
previously read.
Right. If you read it, what did you think?
Oh, well, okay, yeah, I
But
didn't
yeah.
read it.
So I need someone from last class who would have had the opportunity to read it.
Good evening. I still haven't received this link from last class or.
Darius, how come?
I don't know. I haven't seen this link before. I only got it from Ms. Rahman in the chat.
Hold on, hold on. But you have the case now,
I have it because I got it from the chat.
but you're not, okay. I have to send a note to Miguel. I don't know why some people are missing. Okay, so let me see if I could steer you all to where you need to start reading.
Well,
Go ahead.
do you just want a synopsis of what the case was about, or?
That's
don't-
where we start.
Okay, well, I would say the initial issue would have been whether or not the title to the property was fraudulently obtained. And at the heart of that issue was whether or not the daughter and the niece that claimed they built the school actually had an interest in the property, or whether they were just simply being permitted to be there as a licensee. So they didn't really have an interest, but they had a right to be there by permission of the true owner. And it seemed that that was the gist of what the court was considering, and whether or not the test was met for full and fair disclosure, and whether they had attempted to deceive the court as it relates to their interest in that property. Because it appears that I think one of them worked as a teacher at the school and not necessarily as an owner of the property.
Correct.
And so
Operator of a preschool.
right. So they were operating the preschool, but they made it seem as though they owned the property and had built it and had some actual interest in the land, not just a right to be there by permission of the owner. And so certain tests had to be met. And I think the first element of that test was whether or not they had an interest.
Right, so if we go to paragraph, where is it? 13, 12. He's saying, having analyzed the ruling which the appellants seek to impugn, there is no doubt that the learned Chief Justice was only too well aware of the task which lay before him in the respondent's action, which sought to set aside the certificate of title which he had earlier granted to Milton and Daniel Strawn under the Act. So he said between paragraphs 3 and 10, he commenced the task before him by reviewing on one hand the appellant's claim to a possessory title and the evidence which they had adduced in the quieting proceedings in support of their claim. And on the other, the several allegations of fraud set out in the respondent's statement of claim. So he says he highlighted the appellant's claim to have farmed the land over a period of 20 years and to have built 2 rental houses and a preschool on the land, and emphasized the presence in the affidavit of the statutory assurance to the court in accordance with Section 5 of the Act, that the affidavit and papers produced with the petition fully and fairly disclose all facts material to the title claimed and all contracts and dealings which affect the title or any part thereof. Then he went further and he said, after referring at paragraph 11 of his ruling, James Smith J. in Johnson versus Exuma Estates, and highlighting in particular his obligation to examine the grave general question arising from the allegation of fraud which the respondent had leveled against the appellants, the learned Chief Justice, correctly in my view, reminded himself that in considering the respondent's allegations of fraud, he was not being called upon to decide which of the parties had a better title to the property in dispute, but was simply required to decide whether the certificate of title which had been granted to the appellants in the quieting proceedings had been obtained by deceiving the court and ought to be set aside. So you see, even though the court had previously granted a certificate of title. Now, Milton and Daniel are appealing and saying, let's see exactly who should have title or who has title to this piece of land. Anybody else have any comments? Because remember, whenever you file a matter before the court looks at the documents that are submitted. Because he found this case was quite interesting in terms of how they had sought to deceive the court. Yes, Camille, you want to say something?
I was just noting, I guess in section 17 and 18, where he was suggesting that later on it was disclosed that they didn't actually build the preschool, but the daughter actually built it. Is that what I'm understanding?
Yes,
And so that's why they
Yeah.
were saying that what they presented was false. Because they had nothing to do with it. Is that correct?
Yeah, because he said the Chief Justice further observed in the quieting proceedings, the appellants had never disclosed or suggested that the preschool had been built by the respondent and his wife. And it had been they and not the appellants who had been in occupation of the school. The appellants had represented to the court in the affidavit filed that they had built the preschool on the land and had further represented that they enjoyed undisturbed occupation and possession of the property even to the present day. So then he said he found that the contents of the first appellant's letter addressed to the respondent and set out in full at paragraph 19 of the ruling were completely inconsistent with the representations which both appellants had made to the court in their joint affidavit in support of the petition, which represented to the court that they had built the preschool on the land. And I want you to notice how long these matters go on for. So the Chief Justice then highlighted aspects of the evidence given on the respondent's behalf by Mrs. Smith, who testified as to the fact of her occupation of the preschool over a 6-year period, beginning in 2008 initially as the respondent's employee and from 2010 as his leasee. Mrs. Smith also testified that the first time she had received notice of the quieting proceedings regarding the property had been in 2013. And further, that no notice had ever been posted on the property or served on the preschool or on her. So he says, further, he says, he accepted the evidence of the operator of the preschool, Mrs. Smith, and found that the appellants were under an obligation to disclose the fact that they were not in exclusive possession of the property, as they had both alleged in the petition. He stated that the appellants had permitted the court to act on the basis that they were the ones who owned and operated the preschool on the land and had done so from the beginning. They deceived the court to believe that there was no one on the property who was claiming an interest contrary to theirs, reiterating that whether the respondent's claim was valid or not, it was one which had to be disclosed to the court in the quieting action. So they concealed the existence of their dispute with the respondent regarding the land. And the appellants had permitted the court to proceed in the quieting action and act on the basis that they had built and occupied the land exclusively. And the judge was saying that they had abused the process on the quieting of title. So he says at paragraph 38, he says he take the extract from the transcript. Daniel Strawn, under cross-examination at the fraud trial, showed the extent to which the court in the quieting proceedings had been misled by the appellants as to who built the preschool. Question, do you recall the quieting proceedings? Daniel Strawn, yes, I do. Can you explain why you said you and your brother built the preschool? Daniel Strawn, we never claimed that we built the preschool. So after being reminded of the contents of the abstract of title filed in the quieting proceedings, Daniel Strawn then agreed with counsel for the respondent that the information in the abstract about the appellants having built the preschool was incorrect. He then confirmed that the preschool had in fact been built by his niece. So in the face of such a blatant falsehood, coupled with his findings that the respondent and his wife and the appellants had been embroiled in a dispute regarding the preschool, which had not been disclosed to the court as mandated by Section 5, the learned Chief Justice was perfectly correct in law and in fact to conclude that the grant of the certificate of title had been procured by the appellant's deception, and these grounds must therefore fail. Because he didn't give full and fair disclosure. Now let's go to Simon Rodin. Anyone read Simon? It is quite long. It gives you the abstract of title, paragraph 2. It gives you Mr. Rodin's abstract of title. And then it gives you the abstract title by the opponents. And that's on paragraph 9, page 7. You see any difference between the two abstracts of title?
I mean, it seems to be shorter, but I think, because I think in the first abstract, there was a compulsory sort of like a taking by BEC. So it seems to be a shorter abstract. So a lot of things or a lot of conveyances were left out.
You mean in the one by Simon versus the one by the Archers? Simon abstract is in paragraph 2.
Right. So that one, because like I said, I saw a few more conveyances in that one than I did on this. I think this is page 7. So I'm toggling back and forth between the two.
Mm-hmm. Yeah. Simon one is a little bit more expansive if you actually go through it. you will see there is some similarities in the name, but then it begins to differ. So when you look at an abstract of title, let's go through Simon's first.
Okay.
So Simon said in 1789, the Crown granted 260 acres to Alexander Harold. Then he says in 1807, there was a conveyance by William Bayliss to James Webster to satisfy a judgment by James McCarty. So the first thing is we've moved from Harold to Bayliss. So there's a gap in there. Then he says there was a conveyance by James Webster to Anthony Wallace. So if we conveyed it by Bayliss to James Webster, right? And that was the satisfied judgment of James McCarty. So James Webster then conveyed it to Anthony Wallace. Then conveyance by James Webster to Anthony Wallace of 2 parcels measuring 260 acres and 200 acres respectively. So that's 1808 on the 18 and 1808 on the 19 has to be the same 260 because it was 260 in 1789. So I don't see how he's going to do 2 parcels measuring 260 and 200 respectively, because he only got 260 at the beginning. So he must have acquired 200 sometime after that. Then in 1809, he had a conveyance by Anthony Wallace, who got it in 1808, to Timothy Cox. And then then there's the actual conveyance to Timothy Cox. Then there's Crown to David Garner. So you could see between 1809 and 1847, what happened? Between 1809 and 1847, what happened?
Which one of this you referring to again? Not the Simon Rudin one, right?
Simon, yes. Simon on page 2, and I'm on top of page 3.
Oh, okay.
Because see, the land was conveyed by Wallace to Timothy Cox. But in 1847, the Crown.
I mean, initially we were on page 7, right?
No,
You
I just said,
no.
I said there are 2 abstracts of title. One is on page 2 to 3, that's Simon Rodin. And then on page 7 is the abstract by the Archers.
Okay.
Right. So these 2 different parties now before the court with an abstract of title. So they're before the,
forgive me, but this is my first class there. So could you kind of explain what an abstract of title basically is?
so an abstract of title means that when you're going to purchase land, you enter into an agreement for sale, a contract. That's the first thing you do. Now, once you enter into that contract, the person who is selling that land to you has to prove to you that he has good title, which means he's going to prove to you that he has good and marketable title, a title whereby you can purchase your interest in that land. And once you do that, you will get a piece of property in fee simple absolute in possession, which means there are no claims against that land. Then you could dispose of that land as you see fit. So an abstract of title means that you who purchasing the property now looks at the abstract that was given to you by the vendor's attorney, and your attorney now will go back and see how far back he has to go to come to what we call that root title. And the root title means that he must go back either 30 years. So he must look at all the sale and conveyances for the last 30 years. Or if he is able to come to a point where in 10 years, the land was granted by lease by the government, he can stop there. Or the third place he can stop is if that land was quieted under the Quieting of Titles Act. And you call it a certificate of title. And you would see that in the paper sometime. You remember seeing ads in the paper which says, notice, legal notices. Notice, the Quieting Titles Act, 1959. You recall seeing those in the newspaper?
Yes.
Yes, ma'am.
Okay, all right. So that's where a person is claiming that they want this piece of land and they have done what is necessary for them to obtain exclusive possession and a clear title to that land. So that's what an abstract of title is. Going back to prove that, yes, I own this land. And here are the previous owners of this land going back to a good root title. So Mr. Rodin has started his root title back from 1789 when it was granted by the Crown to Mr. Harold.
Okay.
Okay, and then he's giving you the other dates of conveyancing. But what I'm saying is that in 1809, Mr. Wallace sold it to Mr. Cox. But you could see almost 30 plus years later, the Crown gave it to Mr. David Garner. And 20 years later, Mr. Garner dies. And then he made, in his will, he left no residuary estate and the making of no device to the property. So then you see here that in 1954, a lady by the name of Maud Dew conveyed this property to Agnes Rodin. So there's a gap between 1886, when David Garner Cox died, and in 1954, when this lady by the name of Maud Dew conveyed it to Agnes Rodin. Then of
Okay,
course,
so
go ahead.
So you basically following the cascade of events between the two of these different abstracts of title from two different people?
Yes.
Okay.
Yeah. But what we read on page 3 is still the abstract of title presented by Simon Rodin.
Okay.
This is how he is saying that he has good title to all of this land off Tonic Dallin Highway.
Okay, Ms. Archer, I'm understanding everything you're explaining, but one thing would really, I don't really understand, or I haven't really caught up with.
Go ahead.
The Crown granted. What do you mean by the Crown? Meaning what? That
Government.
the government. Okay.
Mm-hmm. Yeah, it's called the Crown.
Okay.
Yeah. So you see where BEC took back 5.6 acres.
So all of this land you're discussing is supposed to be someone's generational land that the Crown gave away?
Not
And they're trying to
generational
obtain
now.
it? They're
No,
trying
not
to get it back?
No, it's not
Yes.
generational. He is claiming that his mother purchased this land. That's what he's claiming.
His mother purchased the land, but the Crown was able to give it to somebody else?
No, the Crown did that earlier in 1847.
Okay, so Agnes Rodan is supposed to be his mother, is what you're
Yes.
saying.
Yes, that happened in 1954.
And Maud Jeanette just appeared out of nowhere.
Yes,
How
because
did
when
she
you read
obtain
it,
it?
I don't know.
It doesn't say, it just says Maud Jeanette you conveyed.
Exactly.
Agnes, how is she, who gave her
So
the
that's
power
a,
to convey?
right.
Who?
So
Agnes.
right. So that's another gap.
Yeah.
So go down to 1963. Agnes Rodan petitioned the Supreme Court for a certificate of title for the remaining 19.3 of the 24 acres acquired from Maud Dew. So certificate of title means what? She's doing a quieting. Then in 1966, Supreme Court granted a title to Agnes Rodan of 11.8 acres of the property sought to be quieted. So in 1974, Rodan avers that he entered into, that this is the son now, saying that he entered into 7.1 and 8.2 acre parcels. Then you have a conveyance by William Brian Stevenson to Rodan of 1.7 acre parcel. Clyde Trico sworn affidavit speaking to Rodan's occupation of the 15 acre tract. Basil Johnson speaks to his occupation of 16 acres of tract. So he have all of these affidavits saying that all of this land is his land.
Yeah.
Okay, so now let's go to the other person who's claiming it's their land. Page 7. The Archers are saying that in 1788, which is the same time that Simon said it 1 year later, they're saying in 1788, the crown land of 200 acres went to Alexander Harold. Then they say the next month, then 1 year later, crown land of 260 acres went to Alexander Harold. Then they say in 1807, notice that the years are a little bit off. They say in 1787, there was a conveyance by William Ballas to James Webster to satisfy a date. Now they have 1807, 27th of April, and Simon has the same date. Then they conveyed property by James Webster to Anthony Wallace of 2 parcels on the 18th of May, 1808, around the same time. Then in 1960, you see the difference? You see the gap? Simon Owen has some dates in between, how the Crown took back the land and sold it to Mr. Garner Cox, how he died intestate. And then it says he died, leaving no residuary estate. So when they say leaving no residuary estate, means that he didn't leave any property behind. So he must have sold it. But it doesn't indicate in here when he sold it to Maud Jeanette Dew. So we go back to the actress now. They say in 1960, there's an affidavit of Louis Edward Livingston Morrison. Swore to being acquainted with William Wallace, Anthony Wallace, and Philip Wallace. So he's saying that they are the heirs of Anthony Wallace. Morrison swears that Wallace's estate devolved to Minvilla Archer Nee Sawyer. So what they did in this 1960 document, this affidavit here, is linking themselves to Anthony Wallace. Then it says, affidavit of Ivan Wallace swore to the estate of Anthony Wallace devolving to Minvilla Archer Nee Sawyer. Then 11 years later, Elsie Franks Ford, found by the Court of Appeal to be child and heiress at law of the late William Wallace Jr., confirming a certificate of title and equity in 1965. Then David C. Bethel, appointed by the Supreme Court in probate as sole executor to the estate of Elsie Franks. And then there's a conveyance between David C. Bethel as the executor of Elsie Franks and George and Spurgeon Archer. So those titles, which one sound more believable?
So you mean between the two different, the one on page 3 and the one on page 7?
Yes.
7. The one on page 7, because it kind of like shows a backtrack of like the different titles. And the first one has like a big gap. This one has an explanation for that gap.
Notice that the second one on page 7 is referring to affidavits. What has Rodin presented in his title? He is presented more what? Certificates of title and conveyancing.
Oh, okay. Okay.
So Mr. Rodin has been in possession of land for quite some time. It says here that Mr. Rodin family has been in adverse possession for more than 40 years. That's how long they've been in adverse possession. So let's look at how the court decided to come to their conclusion. So look at paragraph 19, page 12. It says the Archer's case. They said at trial, the Archers called Samuel Archer, Anthony Curtis, and Desmond Silvera as witnesses. And they said that the Archers' evidence was that their descendants farmed the subject property over the period, operated a lime kiln and mined quarry from the premises to the south of the homestead. They also said that they had a workshop on the property. And they spoke of conversations with Captain Archer about his being a beneficiary to the subject property, through his deceased mother, Minvilla Archer. So now they're giving this verbal discussion of how they own this property through their grandmother, Minvilla Archer. So he says, he and Captain Archer always spoke at length of his plans for the said property and recalls being shown a water well south of Captain Archer's existing home. The well was approximately 75 meters at least from the home. This water well served as their supply for water. He saw Captain Archer farm on this land, farming many plants and fruit trees, cassava, sweet potatoes, sapodillas, and mango trees. He said that there are still many mango trees on the subject property. His evidence was that the farming went up towards the crest of the hill, and he understood the Edwards property to be the west of his property near the dump road. Rodin was not in the picture of ownership of the subject land in question. So Samuel Archer, 56 years old at the time of the trial, says that he was about 12 when he would be taken by his dad to the property in Harrow Road. He said his dad was constructing the dwelling home that they currently live in. He had erected a wall to the north, the west side of the dwelling home, and the dwelling house was built to the east of the dump road off Tonic Williams Darling Highway. After his father built the house and erected the wall, he began farming to the south of the property and went about 2 to 3 acres. So he was also aware of the mine being done with his father's approval, and that was to the south of the house. So Samuel Archer saying that he first encountered Simon around 2003. when he saw him moving through the land with a bobcat, removing fill and palm trees. He lodged a complaint at the Flamingo Gardens police station and eventually commenced action against him. The Archers, like the Edwards, challenged the occupation of Rodin by filing court actions alleging trespass. In that action, which was served on Rodin, Justice John Lyons issued an injunction against Rodin in 2004. The writ was served on Rodin, but he says that the injunction was never served on him. Rodin entered an appearance on August 2004, and the Archers suggested that he was served with the order in October. Because the question is whether or not Mr. Rodin is in possession or whether the Archers are in possession of the land.
Miss Archer, just to clarify, Rodin's mother received the land through the quiet in Titles Act.
Titles Act.
That's how she acquired it?
She bought it, didn't she buy it?
19, what did it say here?
She, in 1954, on the 6th of April, Maud Dew conveyed to Agnes Rodin to 24.94 acres. Then she petitioned for a certificate of title as quieting for 19.3 of the 24.94 acres. So you have one side, Mr. Rodin, whose mother purchased and quieted the rest of the property. And then you have the Archers on the other side saying that they were living there and farming there. And then they saw Mr. Rodin coming with his tractor and digging things up.
So Mr. Archer then was pretty much squatters versus the Rodin, whose mother actually purchased the property and had the documentation to prove that it was bought rather than acquired.
Yes.
Okay.
But the court did have some negative things to say about Mr. Rodin, though. They said that he was very sneaky. He said,
Mr. Rodin probably went about it the wrong way. Instead of just bringing his documents and to let them know that, hey, I really own this property, versus letting them do what they did, and then he decides to swoop in to go and claim.
Because he says, let me see, it's paragraph 49, I think he says. The judge says, Rodin does admit that the asphalt paving of roads and the surfaces on this tract, as well as construction of some substantial structures, took place since the filing of the petition. This occupation is therefore not evidence of Rodin's possession. The unregulated construction, however, is indicative of the stealth with which Rodin engaged with this tract. The latter construction took place notwithstanding an injunction by Justice Lyons, of which I accept he was aware. He was likely not properly served, but I'm satisfied that he was aware of its existence. No building permits were obtained for the construction of the multi-story buildings, and therefore no inspections by the authorities took place. In evidence, Rodin admitted that he used the 1976 occupancy permit for his existing home to misrepresent to the authorities that the permit related to the new construction in order to obtain power. I did not accept Rodin's evidence of possession, and I've approached it with considerable caution. So he even though he knew that Justice Lyon had given him an injunction to stop what he was doing on the property, he still went ahead and he built and he paved roads. And he even put fence around the property. So at the end, of course, Mr. Rodan got the bulk of the property. So even for the Archers, the judge came to the conclusion that he believed what they said, that their father mine there in the homestead was there and all of that. But he said that that didn't occupy all of that land. He said that only took place in the west track towards the dump road. And that's the part of the land that he gave to them. So he said, Rodan is to receive a certificate of title for the 0.67 acre, identified as encroachment by Simon Rodan. The Archers to receive a certificate of title for the northernmost 2 acres of the 7.712 acre parcel. And Mr. Edwards was to receive the balance of the 7.712 acre tract to the north and south of the marked encroachment.
So the Archers got theirs based on word of mouth. So they really won on squatters' rights.
Yes.
But if there was an affidavit, so if it was just people,
yes.
affidavit is word of mouth. So
yes.
they won based on squatters' rights.
Yes.
Powerful.
Yes, they did.
Very powerful.
Yes. But don't forget now, they were trying to get all of it. They wanted all of it, because that's why they filed the injunction against him.
So they was being greedy for something they really didn't own.
Yes.
Yeah, because his mother, Mr. Rodan's mother, bought it outright.
Yes. And then she got a quieting. She did a quieting. She had a certificate of title for the rest of the property that she bought. But what he was doing, Rodan, was going even further than that property.
Mm.
He was building roads and putting fence up, and he was just moving on to acquire all of the land on that whole ridge. And I think what the court turned against him is because he knew an injunction was placed on him, but he continued. And then don't forget, he used an old permit in order to get approval for something new that he had just built.
So he basically lost based on him being underhanded.
Yes.
Even though he might have had proof that it was his, he was being underhanded, and the court had to show him. The court had to show him that we still in control.
Mm-hmm. And the thing is that he also didn't want to, because if you have an injunction and you don't abide by the ruling of the court, you're already seen in a bad light. Now, also in this matter was Mr. Edwards. Mr. Edwards. This was Rita Woods and Alveston Woods, and they were trustees and the beneficiaries of the estate of Headley Vivian Edwards. And you notice that they also were awarded money. They claimed ownership of 7.712 acre tract and the 1.7 acre tract. And their petition is on page 4. They settled their claim.
Because that there was, I guess, generation because of the mother owning it.
Mm-hmm.
And they were the beneficiaries, so they were automatically entitled to some sort of compensation.
So let's look at their claim, because you see at the end that they won their land. So they're saying by conveyance dated the 22nd of May, 1958, land totaling 9.1 acres were conveyed by Joseph Oster Thurston to the deceased Headley Vivian Edwards, and further by a crown grant dated the 5th of March, 1975, and recorded in the registry, belonging to the deceased. That sometime after 1958, the deceased entered into occupation of the said land without his wife and children, as he was separated and remained in occupation until his death. About 4 years before the date of his death, the petitioner, by force and threat, prevented the deceased, being a Jamaican national, from continuing to occupy his land. So particulars of the threat. The petitioners, by the threat of or by the use of a gun, prevented or interfered with the deceased in the occupation of the deceased land. That by accusing the deceased of not being a Bahamian citizen and that he was not entitled to the land, and that consequently the authorities would remove him from the land. You see how bigoted he was? That partly as a result of the said threats, the deceased became ill and spent a considerable amount of time in the hospital. By an application in the court under the Mental Health Act, granted by the trustee, Rita Wood was appointed receiver in a matter of the real and personal estate of the deceased Headley Vivian Edwards. That the occupation and construction of buildings and fence are not visible from the public street and was reasonably accessible only from the land of the petitioner and not from the public road. Consequently, the possession claimed by the petitioner was in secret and not open to the public or the adverse claimants. So sometime in 1988, the trustees sought to sell the said land to Mr. Cooper and have the land surveyed, but the petitioner offered to purchase the land. The Supreme Court action was taken by the trustees to remove Mr. Rodin off the land, being the 9.10 acres as particularized in their statement. And at a time unknown to the plaintiff, the first defendant, Simon Rodin, without the plaintiff's knowledge or permission, built or caused to be built 3 structures on 0.67 acres of the said land. So you see what he was doing, right? He knew the land was not his.
Yes, so in a way, he was actually also being a squatter. That's why they charged him. So there he had to settle.
Yes. And so they claimed that he was a trespasser of the land. But he denied it.
And he probably knew that they forced the Jamaican national off his land because of the laws back then. So with the knowledge of that, he just felt because it was just open right for the picking.
Yes, yes. So, and then this comes back to when we did chapter 1. When we speak about the Bahamas having unregistered land, this is the difficulty that you see. So imagine if you enter in an agreement to purchase an interest in land and you don't go through an attorney. You purchase the land, now you go into the bank to get a mortgage. And now the attorney now has to go and get root title of this property. And now you can see the obstructions.
Correct.
That happens, right. And that is why you need an attorney from the very beginning, because our land is not registered.
Well, good thing for the Jamaican, his own was. So his family had that to back up the fact that this belonged to him.
Mm-hmm. Because he's Mr. Rodin. And see, the thing about it, Mr. Rodin went and built on it and fenced it off and put roads on it. He did all of that. Okay, now let's talk about the stump exemptions. And then we'll do the last case at the end, Montague and Westminster College and Mission Baptist Church. So under the Stump Act, application for exemption from stamp duty on the acquisition and mortgage of property may be made for or on behalf of first-time owners of a dwelling house valued at $500,000 or less. Of course, it would be subject to VAT, but it could receive a partial or full exemption depending on different values. So after stamping, the title document is sent for recording at the Registry of Deeds and Documents for a nominal recording fee. It's not much. The Stamp Act brought about several changes with regard to stamping documents. The applicable stamp duty will be the stamp duty that is enforced at the date the documents or the transactions are presented for stamping, not the date when the transaction was completed or the document was drafted. Stamp duty will now be paid on the greater amount of the purchase price or market value of the property, as evidenced by an appraisal, by an approved appraiser, and not just the purchase price or the consideration mentioned on the title document. So the definition of mortgage also includes now promissory notes made supplemental to or in connection with a mortgage or a charge. Stamp duty is also required to be paid on the combined consideration when there are property transactions involving a transfer of land on a construction contract. Transfers of property from an individual to a company, all of whose shares are beneficially owned by that one individual, or transfers of property from an individual to the trustees of a trust or a class of persons, which is unalterably limited to that same individual, his spouse or his children or other issue, those are exempt from stamp duty. The treasurer may stamp any unstamped or insufficiently stamped instrument after its execution, provided payment of the unpaid stamp duty on a surcharge of 10%, where 6 months or more has elapsed from the date of execution of the document. The treasurer can also take into consideration the value of any adjoining property to a dispute, to a property that's in dispute, sold within the preceding 12 months in determining the liability for the payment of stamp duty of the disputed property. A 2.5% stamp duty on the value of a deed of conveyance, assignment, or transfer of real property at 100,000 and under, and 10% of the value in excess of 100,000. A stamp duty of 2.5% of the value of the interest in real property is levied on a transaction or instrument, which is treated as a transfer of land, which has the effect of transferring an interest in real property by virtue of the transfer of issued shares or of the beneficial ownership interest of a company which owns real property in the Bahamas. Stamp duty is payable for a deed of rectification or confirmatory conveyance, where stamp duty has been paid on the initial conveyance, or where there is no change in the parties of the conveyance. If there's a transfer of mortgage and further advances are made by a new licensed lending institution, stamp duty is only payable in the further sums advanced by the new licensed lending institution. Where there is a transfer of mortgage to the same property, the instrument evidencing the satisfaction of the subsisting mortgage and the creation of a new mortgage is exempt from the payment of stamp duty. The treasurer may stamp an application for the exemption of stamp duty on any instrument made pursuant to the provisions of the Stamp Act, where approval for the exemption has been previously granted and where the title document to which the application refers remains unstamped, subject to payment of the surcharge and evidence that approval for the exemption had previously been granted. Now VAT. I know everybody must be happy that VAT is now reduced to 10%.
The cost of everything went up anyway, so that 2% is being picked up in other places. So like, really, what did that do?
And things have gone up as of December by 8%. And I think they announced last week that certain items will go up by 40%.
Oh, and see, y'all in Nassau have it good, because in Grand Bahama, double that, because we have ports as well as government. So if it's 8% in Nassau, it's 16% in Grand Bahama.
And how much you think it is in the outer islands, Cat Island and the
It's
rest?
even worse, because when we had gas for $3 in Grand Bahama, Cat Island had it for $8 a gallon. So it's crazy.
Mm-hmm. Yep. So in determining the amounts chargeable on conveyance for the purposes of VAT, the VAT controller under the rule may consider the purchase price and appraisal value of the subject property. And you notice now that even with real property tax, I think the government put in the newspaper for those persons whose properties were reassessed, that they could contact the Department of Inland Revenue, because that means that they have to pay more taxes. So under the VAT legislation, property transactions over 100,000 now attract the same duty as stamp duty rate of 2.5% for 100,000 and 10% for over 100,000. So the purchaser and the vendor may decide to split both the stamp duty and the VAT depending upon their negotiation agreement regarding the sale and purchase of property. Note that the VAT rules do allow a purchaser as a VAT registrant, they can claim input taxes on the supply in accordance with the rule on real estate. With regard to the payment of closing costs, VAT is normally paid to the VAT controller and is based upon the determination of the VAT to be paid on the property transaction. The VAT controller may request that an appraisal report be submitted that reflects the true market value of the property if he is not satisfied with the consideration amount listed on the conveyance. The payment of VAT, the relevant stamp duty of 2.5% is paid to the public treasury, and the title documents are subsequently submitted to the registry of deeds and documents for stamping and recording. The VAT is charged also on professional services, inclusive of legal fees, appraisals, title searches, and real estate commissions. First-time borrowers who are exempt from the payment of stamp duty are also exempt from the payment of VAT on property transactions. So the next pages I've listed the standard fees. For VAT. And notice that there is no VAT on real property tax. So even though it was reduced from 12 to 10, with the reassessment, of course, that means that you pay more. So the new assessment method for valuing property has been implemented. The new method will allow the chief valuation officer to consider special market conditions in existence on the date that the property was sold. So owner occupied property, first 250, there's no real property tax. But most people are going for properties over 250 now. The appraisal fee varies from 350 to 500,000, and it depends upon the scope of the appraisal report and any negotiated fee. So most financial institutions and the public treasury require appraisal reports from an approved appraiser. And normally there's a list of approved appraisers that are issued by the banks or the credit unions. Some financial institutions require comparative analysis of properties which have been sold or purchased within the last 6 months to a year in the same area or the location. And that's also subject to property to be mortgaged or financed with the appraisal report. And this increases the standard price of an appraisal report, which is normally paid by the purchaser or the mortgagor. The title search is normally about $350. They take about 3 days for an expedited search, 2 to 3 weeks, depending upon the scope of the search. And now you can see why when you send the property to the title documents to the lawyer to do a research, why it takes such a long time. The recording fees is $450. Mortgages, bank service fee, mortgage fee, it varies. Legal fees, again, is 2.5. Stamp duty is 1%. Satisfaction is 1%. And of course, once the mortgage is paid off, the recording fee again is another $4.50. And it takes 6 months to get your documents back. I've listed here the supplies of real property, which are exempt from VAT. And most of it have to do with inter vivos gift. You know what inter vivos means?
No, ma'am.
Okay, so inter vivos means while you're living. So any gift of real property that you give while you're living, it says is held by the transferee for at least 7 years from the date of the transfer. And that is where there's no change in beneficial ownership, which means that if it's going from you to something else that you own, like a company, then there is no charge. The only transferees are the transfer of the transfer spouse or the parents or children, a company, all of whose shares and every class are beneficially owned by yourself. Or it could be a trustee where the express and unalterable terms of the trust exclude the trustee from taking or receiving any title to the trust property. Other instances could be a foundation where the only beneficiaries are the founder or the founder's spouse or children. If it's a gift to a charity or a religious or non-profit organization, it is exempt. Any real property made pursuant to an adjustment order under the Matrimonial Causes Act, that is exempt. Of course, first time dwelling under 500,000 and a transfer between one licensed lending institution of a home mortgage or a home mortgage combined with another domestic loan is exempt. And the transmission of real property on the death or bankruptcy of the owner of the property to their personal representative of trustee or trustee in bankruptcy is exempt. So let's look at Montague Investments and Westminster Mission Church. Who read this one? No one read this one? Montague Investments is claiming that Westminster College at Mission Baptist Church is on their land. Westminster operates a college on Blake Road and is adjacent to the land owned by Montague. Westminster filed a defense alleging that the land which it occupies was purchased by Mission Baptist Church in 1984. So let's see how this title goes. Paragraph 6, page 3. It says, by an indenture of conveyance dated on the 18th of September 2013 between Ira H. Smith and Montague, Montague became the owner of 6.6 acres of land on the western side of Blake Road and is bounded by land now or formerly the property of Richard Carlson, and it runs northeasterly by Blake Road and southeastwardly by land comprising a 1 acre tract now or formerly the property of J&O Properties. The indenture of conveyance was made on the 17th of February, 1984. James Pratt conveyed to the church all that piece and parcel of tract of land that's on Blake Road. In or around 2004, Mr. Stephen Carey, a director of Montague, visited the land and discovered various encroachments. He discovered a wall, which is part of the entrance gate of the college. He also discovered a road leading to the entrance of the college, which, according to him, also encroaches upon the land. Further persons associated with the college have been parking on the land along its northern boundary. So Montague averred that during a site visit to the land, that's paragraph 10, page 4, in 2014, Mr. Carey noticed that Westminster, its servants or agents, had wrongfully constructed on the land a fence and a wall, which is a part of the entrance gate of the college. According to Mr. Carey, the access road leading to the entrance of the college also encroached on the land. And upon further instruction, Mr. Carey noticed the boundary marker could be seen in the tarmac of the road. He alleged that Westminster, its servants or agents, had wrongfully paved over the boundary marker. Any comments there?
You said the person that did the inspection wrongly paved over the boundary marker.
Yes.
Would you-
Paragraph 10, page 4.
So whose fault is that? That's the person that did that. That wasn't intentional, right?
Of course it was intentional. How do you think people go about acquiring land and quieting it?
You said the definition of quiet. What is the definition of quiet again?
Quieting land is when you go on a piece of land, you have to stay there for 12 years. You farm on it, you fence it in, and the neighbors around you have to see you on that land because you're gonna have to get people who can say that you've been on that land for 12 years.
Yes.
Because what you're going to do now is you're going to go to the courts to say, I am the owner of this land.
So let's say if you, I guess, let's say they plant a tree or something and it's been there for a certain amount of time, I guess they could go back to it to say, well, that tree has been there for 12 plus years. So they could consider that as a reason of proof that it's their land.
They gotta do more than that.
Yeah.
You have to do more than that. People have to see you and say, yes, that is Mr. Smith's property. He's been there. Now the thing of it is, when the rightful owner comes, right, and the rightful owner says, "What you doing on my land? You should not be on my land. This is my land. I have papers for this." Time's supposed to stop. Which means that if you were on that property for 3 years, planting and moving trees and putting your little picket fence, when that person came to you and says, "You're on my property," time stops. So the next day, day one begins again.
Okay.
You have to have 12 years of I guess pretending that you own this piece of property.
Like undisturbed,
Yes.
undisturbed, like you haven't been, right.
Exclusive possession.
Sorry, in this particular instances, weren't they on the land for more than 12 years?
You mean the school?
The school as well as the road that was paved. Wasn't that there for more than 12 years?
Let me see, this is 2014.
2005,
From 1984.
the school?
I think
I
also
see.
in the case they didn't, they initially said that the other people owned the land, so they denied that the land was theirs and admitted to it being owned by the Montague Investments. And then they tried to change it to say, oh, we were actually taking part in adverse possession, which essentially is quieting. But then the
Yes.
court said initially y'all already admitted to it being owned by somebody. So that's what Ms. Archer said. If you
Mhm.
admit, or if somebody said, the real owner says, this is my land, or if you admit that it is owned by somebody else, then you
Yeah.
cannot claim that you adversely possess the land. You
Exactly.
said it
The
was
owner.
owned. Right.
Yeah.
Mhm.
So initially, if he had said, this is my land, he would have had to it.
You mean the school?
Church and the school, Westminster.
But the first thing is if you pave over the marker,
You're wrong.
you're wrong.
Well, because you trespassed.
Yes, you're wrong.
Mark was there.
See on paragraph 28, page 8, Mr. Carey stated that during one of his subsequent visits to the land, he met with Dr. Cooper. He mentioned to him that certain areas of the college were encroaching upon the land and requested that all encroachments be rectified. By email dated March 2014 to Dr. Cooper, he made a further request for the fixtures on the land to be removed. Then he wrote through his attorneys to the principal of the college demanding a removal of the wall and road from the land, and for all employees and visitors of Westminster to cease their trespass on the land. Then he sent another letter to Dr. Cooper, but he got no response. So they knew they were encroaching on the land.
And they thought they just thought they could get away with it.
Yes. But the thing is that Mr. Carey was telling them over and over again, you're on my land. So even if they had gotten someone to survey the land, let's say they didn't realize it was going over the marker, even though they knew.
Mhm.
Everybody knows the marker on for land. But they were trying to take the land.
Yeah, that's why they didn't get anybody.
Mhm.
to survey. Because they knew.
Yeah, they knew. It says here on paragraph 54, Dr. Cooper confirmed that there was no school on the property prior to 2000. Classes began in 2000, so prior to 2000, there was no school operating on the Blake Road property.
Mhm.
Dr. Cooper admitted that he cleared an area of land and was encroaching on property belonging to Montague along the boundary between the property belonging to the church and Montague. He further stated that they did their best to stay within what they comfortably felt was their property. Dr. Cooper concluded by admitting that the portion of Montague's land along the boundary line was cleared and filled in or around 2004. So the judge says, I find as a fact that any substantial acts of trespass by the defendants on Montague's land, including the construction of the wall and the fence, must have commenced in or around 2004 after the clearing and filling in of the land. This conclusion accords with the testimony of Mr. Williams, who asserted that upon his review of the photographs taken in January 2004, there may not have been any activity, any buildings, any clearing between 1999 and 2004 on the land. So they knew exactly what they were doing.
Yeah.
They knew. So he says at paragraph 69, page 16, he says a trespasser must establish both A, factual possession and B, a requisite intention to possess. So that's what they had to prove. He said that simplified, the two elements necessary for legal possession was a sufficient degree of physical control and custody and an intention to exercise such custody and control on one's own behalf and for one's own benefit.
Intention to possess.
Yeah. So he says Westminster also has to satisfy the court that its possession was open, undisturbed, and continuous for 12 years. See, those are the key words there. If you're going to say that you have factual possession and the intention to own this property, then he's saying that it has to be open, which means people must see you on the property. It must be undisturbed, which means the owner must not come there and tell you, take this down. And
Right.
second, it has to be continuous. There must be no break. So the evidence demonstrated that in and around 2014, when Montague discovered encroachments to his land, Mr. Carey approached Dr. Cooper and mentioned that certain areas of the college were encroaching upon the land. This does not satisfy the requirement of uninterrupted or peaceful for 12 years. So that's what I'm telling you. Once that owner says, you're on my land, time stops. And then it starts running again. So he says, he concluded in paragraph 79, he says, Westminster admitted in its defense and in the affidavit of Dr. Cooper that it cleared an area of the land which its patrons used for parking. The survey plan of the Surveyor General clearly shows that the cleared land is on the land and not on the defendant's property. In addition, the wall and fence pole are squarely on the land. Further, as part of the defendant's entrance road encroaches upon the land. This is also reflected in the Surveyor General's survey plan. I should add that the Surveyor General was a neutral party in the proceedings. And so he says, what he gave them? He said, Dr. Cooper averred in his affidavit that more than $200,000 was spent on over the years to construct the road, including the fill, the tractor services, the grading, and other materials. Indisputably, he should have been able to produce an invoice. That said, as a fact, that any use of the land would have taken place in or around 2004. Therefore, it cannot be said that Westminster occupied the land openly, undisturbed, and continuous for 12 years, since Montague began to assert his ownership in 2014. So the court declared that a declaration is granted to the effect that the defendants have no claim or right to the plaintiff's land. The defendants are to pull down and remove the wall, the fence, and the portion of the road that encroaches on the plaintiff's land within 3 months. A perpetual injunction is granted, restraining the defendants, whether by themselves, their servants, or their agents, or otherwise whosoever, from trespassing on the plaintiff's land. And damages for trespass are to be assessed by the court upon an application by Montague. And of course, Westminster College and Mission Baptist Church have to pay Montague's legal costs.
Wow.
So those who didn't have the opportunity to read it can sit down and read it. And you'll see how important it is to have an abstract of title. And you'll also see why a lot of countries, other countries around the world, have moved to registered land rather than unregistered land. So our last area is on leases. So a lease, as you know, is a contractual agreement between the landlord and its tenant. And a lease agreement will talk about the duration of the rental, the purpose, the amount, the terms and condition of the tenancy, and the rights and the duties, along with the responsibilities and obligations and any restrictions. So a lease can be for short or long term, and there are certain characteristics that must exist for lease to be considered a valid lease. And what should that be? The tenant must have the right to exclusive possession of the premises. So that means that once you enter into that contractual agreement for a lease, exclusive possession means that you have the right to be inside and not be disturbed by the lessor. If the person granting the lease remains in general control of the property, then no tenancy is created. There's no defined premises for the lease, only a contractual obligation to provide storage for goods with no defined space. This arrangement would be considered a mere license and not a tenancy. So let's say if you have a huge building and you're going to store items in that building, you don't have a lease because there are other tenants. And so only thing you have is a mere license to occupy a space wherever they decide to put it. A lease cannot be for an uncertain period. And a lease must be created in the proper way, following the legal formalities. Because a lease creates a legal estate, and which means that it is enforceable and it can be assigned. Because remember now, if the person owns that property in fee simple absolute in possession, that means there is no liens against the property. The property is not being used for no security, it's free and clear. He can lease that property for a certain number of years. And the person he leases it to can lease it to someone else for a period lower than the period that he has leased it for. So there are different types of commercial leases. A lease could be granted for a fixed period of duration. Both the commencement and duration of the term of the lease must either be certain or rendered to be certain before the lease takes effect. And the lease for a fixed period automatically determines when the fixed period expires on the lease. So normally you still lease as a 1-year lease, a 2-year lease, a 3-year lease. If it's a commercial lease, it may be for 5, 10, 20, 25 years. A yearly tenancy is one that continues from year to year indefinitely until terminated by a proper notice. And so the contract will be year to year, but then they'll have clauses that speak to termination, certain events that would trigger the end of the relationship. So notwithstanding the death of the landlord or tenant or the assignment of interest. So generally a yearly tenancy may be created by implication in instances where a person occupies premises with the owner's consent, and in circumstances where the tenancy was intended and rent is charged or measured for a year, is paid and accepted, unless there's evidence that there's a different type of tenancy. Monthly, weekly, and other periodic tenancies may also be created in the same way as a yearly tenancy, whether by express agreement or it could be by inference. A tenancy at will is where a tenant, with the consent of the landlord, occupies premises as a tenant on terms that either party may terminate it at any time. That's tenant at will, tenancy at will. Unless the parties under tenancy at will agree that the tenancy will be rent-free, the landlord is entitled to some compensation for use and occupation of the premises. That tenancy at will terminates when either the landlord or the tenant does not act or does any act that is incongruent with the continuance of the tenancy. That means that either one gives the other one notice that they no longer want to be in that premises. Now, when you do a commercial lease, there are certain clauses that should be present. One is the parties to the lease, the actual premises, the rent, and the duration of the lease. A commercial lease should specify the rights, the duties, the responsibilities, and the obligations of the landlord and tenant. The parties may also agree by bound the usual covenants, like the covenants to repair, for insurances, indemnification, leasehold improvements, options to renew, termination, notices. All of those are the usual clauses that are in a lease. Those are the express terms. In the absence of these express terms or conditions or the usual covenants, there are implied covenants. And those implied covenants is quiet enjoyment, which means that when you lease a property, you don't expect that the landlord will keep coming in all the time, disturbing you that they want to come inside. They need to check this, they need to check that. And this allows the tenant to recover damages from the landlord if the person to whom the covenant extends physically and substantially interfere with the tenant's enjoyment of the demised property. In addition to the implied covenant of quiet enjoyment, a landlord has an obligation not to derogate from his grant to the demised premises. So he is ensured that certain premises are fit and always in good repair. And that's why when you enter into a lease agreement, it is always good to read the rights and the duties and the responsibilities and the obligation of both sides, the landlord and the tenant. The tenant has an obligation to pay rent, rates and assessments, and not to commit waste, and allow the landlord to view the demised property to make repairs in the absence of express terms and conditions. So you'll see later down when we do some other cases where persons would have entered into a mortgage, and I think I have that case. They enter into a mortgage and then they rent the property out, and then they make an agreement with the tenants to pay the mortgage in their absence. And then what do you think happens? I hope I can still find that case. What do you think happens? The tenants.
The tenants
stop.
don't make the payment. They stop the payment.
Yes,
Stop the
yes.
payment.
I hope I can find that case. That was a very interesting case.
And then they get repossessed.
And guess who purchased it?
The tenant.
The tenants.
The tenants.
Yes, the tenants purchase it. Yes. I have to make sure I find that case. So now you understand what abstract of title is. And you now understand when they talk about the Bahamas having unregistered land and what it involves. And now you see why it takes, I guess, quite a bit of time when a lawyer is carrying out his search and going to get root title for property. And also why it is expensive, because it does take quite a while and it requires a lot of time. Any questions?
So if I have a property that's not registered, I have the conveyance, but it's not registered, I still need to go through a lawyer?
You should, because how do you know if you have good title?
Okay.
You need that comfort that you have good title. Because someone else can then take you to court and say that they have a better title than you.
Right.
Then what happens? You've already paid the seller. Of course, you know, the seller disappears after a while. So your money would have gone down the drain.
What if there's no seller involved? It's something transferred from a parent to a child. Crown land. Same thing applies?
No, now when you say crown land, that means that they would have gotten from the government itself or quieting of title. So if the property is coming to you and that property prior to coming to you was via quieting title, then you already have good title.
Okay.
You see what I mean? But if you're going
Yes,
from A to B to C to D to D to E, D to F, and then you have a title, then you need a lawyer.
Okay.
Because you have to make sure there's no fraud nowhere in there.
And while we don't have a registered system, documents, deeds and documents are still registered in the,
Yes.
right, okay.
Mm-hmm. And remember now, it's always first in time. So here comes someone sells you a piece of land and sells it to me, but I register mine before you.
And when you say register, you mean record, right?
Yes.
Okay.
So then you're stuck. Because you only have a piece of paper.
Yep.
So the person who records their document first, even if they would have paid some vendor this money for this property after me, if they go and record this document, this conveyance in deeds and documents prior to me, they have precedent over me.
Yes, first in time prevails.
Okay.
Yes. So next week we're gonna do 3 and 4, and I will send you some cases. I think I'll use it from the register. I'll double check with Miguel before I send it out. So I'll probably let Miguel send it to make sure he sends it to everyone. I'll send you some cases to read. I'll try and do it before the weekend, so you have enough time to read them, okay?
Yes, ma'am.
Okay, all right. Well, have a good evening.
Thank you.
Yes.
Good evening.
You do
Okay, good evening.
likewise.
Good
Take
evening,
care.
everyone.
Good evening.
Good evening.
Good evening.
Oh.